we're going to talk about actually two chapters tonight because you've got negligence and malpractice, and that's the one we'll start with. So how common are the mistakes that cause negligence? In one study looking at errors in 3 surgical units, they found that some medical errors were made with almost half of the patients, scary, isn't it? And 18% resulted in serious consequences. The good news, I guess, for those providers and healthcare workers was that only 1% of those patients sued. Sorry, I'm going to just hold on just a second. I left the door open and my dog saw an opportunity to take advantage of that. So that's really hard to believe that only 1% actually ended up in a lawsuit. So of the ones that are filed, why are they filed? And these are the reasons that people file lawsuits. Person believes that they were harmed. Of course, they may or may not have been. They may have filed their lawsuit with the wrong person, and it may not be an example of malpractice. Remember that for malpractice to occur, you have to have done some harm. The person names the nurse practitioner because they're a member of the team, not that they necessarily believe that they harmed them. And then insurance damages are required to report damage awards to the National Practitioner Data Bank. If there is no damage award, then nothing is published. And so if you were in a lawsuit and you decided to settle yourself and pay the money yourself, that would not be registered with the National Practitioner Data Bank, which I found pretty interesting, that you can pay off your debt, so to speak, and not have it registered anywhere. So the incidence of successful malpractice award with an MP is 1 in 1,016. And the incidence of malpractice lawsuits is really low too, it's 2%. What do you think contributes to that? That we don't get sued very much?
I think it's our approach to care.
I think you're right, Martha. If you show an interest in the patient, you genuinely are concerned and involved with them, then they're not as likely to sue you.
Yes.
So what can happen to an MP who is sued? Well, they can feel like they ought to quit nursing. Are you all with me still? I don't see your pictures anymore. They doubt their ability to make decisions anymore because they feel like, they weren't adequate to begin with. Sometimes they seek out consultations with other providers because they're, again, unsure of their own competencies. They might resort to over-referring. They can miss days of work while they're testifying in their court case. They'll have to incur some legal expenses and mount a defense before the state licensing board, and they might be investigated by the state licensing board on top of having a lawsuit if there's any question of negligence. Have you ever known anybody that was sued?
No.
No. Well, it would not be a pleasant thing to go through. And, I mean, it would be enough probably to make you want to quit. And because you'd just be so unsure that you could do anything right after that. So the life cycle of a lawsuit, it starts with the filing of the pleadings with a state court, usually in a county where the incident occurred. Some states direct the malpractice action to an arbitration panel, and then either party, after that decision is reached, may appeal, in which case there will be a trial. At trial, a judge decides in favor of one party, and they may then appeal to a higher court, even to a federal court, which may or may not accept their appeal. And it's really unusual for it to go to the U.S. Supreme Court. Public cannot access state trial court proceedings unless there is an appeal. So you would have to go to a newspaper to be able to determine that there was a trial, and it's only if there's an appeal would it be registered where you could find it. And I had one case of a nursing student who had in Missouri, I was in the state of Kansas at the time, had a second-degree manslaughter charge against him. And actually, you would have had to go to the newspaper to know that he had raped and sodomized an elderly woman, and plea bargained his case down to a second-degree manslaughter charge because there was no record. He told me that he had been in a barroom brawl and had killed a man. 6 weeks, I was the dean and director of the program. 6 weeks before he graduated, he raped, sodomized, and brutally beat to death a young, beautiful co-ed in the nutrition department. So he was convicted of that and did go to jail, where he still sits. His name was Gary Clapus. It's public record. And that radicalized me to want to do background checks nationwide. So I went on a campaign throughout the United States to make sure that that happened. But the trial was never published. There was never any record. So he showed me the papers where it was second-degree manslaughter. And I would have had to go to the county, like this says, to have found those records. So it was a terrible event. I just want to say that. So what is malpractice? It's the failure of a professional to exercise that degree of skill and learning commonly applied by the average, prudent, reputable member of the profession. Negligence is the predominant legal theory of malpractice liability. So negligence involves failure to follow up, failure to refer when necessary, failure to disclose information to a patient, and failure to give necessary care. So negligence probably involves a lot of things that you hadn't even thought of. I know when I read this, I was amazed at what was in there in your textbook with regard to negligence. So negligence can get you in trouble just as easy as malpractice does, or can. The elements of malpractice. Well, to the plaintiff, the MP's conduct fell below the standard of care, so they have to prove the malpractice, and they must show that the MP owed a duty to the patient, that the conduct caused the injury, and that the plaintiff was injured. So I think, some of the examples that were given is if you had a patient and he was allergic to penicillin, and you gave them penicillin despite the fact that you knew they were allergic. But if nothing happened to that patient, then you cannot be sued for malpractice. They have to have been harmed in some way, believe it or not. On the contrary to that, if they, you ordered some medicine for them, you gave them good instructions, and they didn't follow the documented instructions that you gave them, again, it would not be your fault. You didn't cause the harm. They caused that to themselves by overdosing on whatever medicine that you had given them. For any of this to occur, you have to have a duty established to the patient. And a duty exists if there's a provider-patient relationship in the office, on the phone, or a casual conversation with someone else who is not officially the patient. So if you agree to give advice or treatment in any setting to somebody, then a duty is established. If the injured party believes that there was a provider-patient relationship, then there may in fact be such a relationship. So that should kind of put you on notice if you're at church or you're in a social group and they say, what do you think about my leg? You know, I injured it the other day. Do you think it's broken? And if you tell them, oh no, I don't think it is, and it truly is, then you had a duty to that patient, and so you would be held liable for any pain and suffering that they had between when they finally got it treated and when they had talked to you. So be careful about those casual telephone conversations. You can decide, of course, not to engage in them. Just tell them that I'm sorry, but that's not anything that I do. Sometimes you might be asked, you know, on your in your office, would you write a prescription for me? I think I've got a strep throat. And then they end up and they have more than a strep throat in the back of their throat. And you didn't give them the right things to send them to the hospital because they needed to go, then you would be held liable. And sometimes friendships go out the window when there's harm. Now, what is considered the standard of care? An NP who uses reasonable, ordinary care, skill, and diligence, as any of the NPs in good standing, is practicing a standard of care. So every time that you do something, you are compared to another fictitious nurse practitioner who has the same kind of education and qualifications you do. I can give you another example. I had a director who engaged in house fraud. If you remember back 2 years ago, there was a housing fraud going on. Well, she was involved in that. When she went to court, because she had a doctoral degree, she was held to a higher standard, and she too sits in the penitentiary. So they are doing what a reasonably prudent MP would do. So the higher your education, the higher they're going to hold you for your credible status. For example, an NP providing primary care can be held to the same standard as a physician providing primary care. And an attorney may list other NPs to testify that the NP met the standard of care, and then the jury or judge decides if that standard of care was met. So those are called expert witnesses, and I am a legal nurse consultant, and I have done cases for people before. The last case I had, I could not agree that the nurse practitioner had done what they needed to do, so I didn't get to be their expert in that case, of course, because I wouldn't support what they were trying to do. But I told them that on the front end. If you want the truth, then you need to hire me. Otherwise, forget it. So the causation of injury. The breach of the standard of care must have caused the accident. And this is another example. If an MP provides an elderly patient with a drug that causes dizziness, and the patient does not take the medicine on the way from the office, but falls due to dizziness from rising up too soon, then there's no breach standard of practice related to the fall, because the medicine that the nurse practitioner gave that patient was not the reason for the fall. So you have to establish that there's a cause and effect relationship. So, true or false? If there is no injury, there is no malpractice. What do you think?
True.
True. Absolutely, that's true. If there's no harm done, it doesn't matter how lousy you did. you're not going to be sued for malpractice. Here is the, have y'all ever heard of the National Practitioner Data Bank before?
Mm-hmm.
Martha has. What about you, Lauren or Jana?
No, I haven't heard of it.
Okay. Well, it can impact you, and so it really is a repository for damage awards, where the insurance companies have paid off on behalf of their clients to injured parties for successful malpractice claims. It also records adverse reactions against providers by licensing boards, hospitals, and professional quality assurance committees. It is under the United States Department of Health and Human Services. It really was developed to encourage hospitals, licensing boards, and other healthcare entities to discipline those who engage in unprofessional behavior and to restrict the ability of incompetent persons to move from state to state without disclosure of their previous dangerous behavior. So if the provider pays the injured party directly, then they do not need to report it. So they are required to report adverse licensure actions. Hospitals are required to report adverse clinical privilege actions, and professional societies are required to report adverse professional society membership actions. If you are interested, you can go into the National Practitioner Database and search yourself and see if anybody has ever filed anything on you. Or if it's free, you can go in there and look. It's not all that hard. I tried to do that the other day just because of this class. But you can go in there and check yourself out, see what they say, if anything about you.
Dr. Mars.
So,
Dr. Mars, this is Letitia.
Uh-huh.
I have a question. So it sounds like your name could be in this database and you not be made aware of it?
Well, that's why I think it'd be a good idea to go in there and see. Certainly, if you've had no trouble from anybody, it's unlikely that you're in there. But those kinds of things I think are important to know, so you can go in there and check it out and make sure that, there's not anything in there that you don't want in there. Or if there is something in there you don't want in there, that you have an opportunity to appeal it, to get it out of there. But just for fun, I would go in there and look. I guess it's possible that, something like that could be in there and you didn't do anything.
Thank you.
You're welcome. But I went in there. It's not too hard. I didn't actually finish it, but I did go in there, and the process, looked like it was going to go well. But what I did is I got almost to the end, and then I backspaced, lost the whole thing, and I'm like, I don't want to do this again. But it's not that hard. I would go in there and look just for fun if I were you all. Now, some places in some states, you have to have practice guidelines or protocols. And these are some helpful hints about if you ever have to establish those. They shouldn't be so detailed that they constrict your practice, but they should be based on evidence-based practice and widely used resources and references for those guidelines. And it's okay to use a published set if you have them, but you need to follow them. And if they are inappropriate for a patient, you need to say why you didn't do it. What was the reason that you veered from that guideline? And then document if the patient don't comply with what you've asked them to do. How to prevent lawsuits. Be careful about establishing patient-provider relationships. We already talked about that. Casual ones can get you in trouble. Know the standard of care and practice within it. As long as you're following the standard of care, you're looking at some of the guidelines and you're going with them, you should be fine. Follow the protocols that are adopted by the agency. if they have them. One of the reasons that providers, and this is very important to know, one of the reasons that providers get reported to the State Board of Nursing is because agencies don't provide the protocols that they should, and so to keep from getting in trouble themselves, they'll throw the nurse practitioner under the bus. So it's real important to know about the protocols that are provided. Certainly you should follow them, but if there's some that are not there, then you should ask your agency to provide them. Take a conservative approach. It's better to be safe than sorry is a good little thing to go by. Rule out the worst diagnosis first. Know what you can and cannot do, and follow up with your patients. That's very important. I know a lot of people don't do that very well. They'll say, oh, if you have any trouble, come back and see me, when actually they ought to be having them come back to make sure they've not acquired an infection and that they're okay. So, what to do if you're sued? You should call the professional liability insurance company to report the lawsuit, and hopefully you have your own malpractice insurance. I can tell you that your employer will look after themselves. You may be left to look after yourself on your own. So it's real important to have your own malpractice insurance, especially as a nurse practitioner. Do not talk about the suit, there's a typo, with anyone but the NP's attorney. That's the only person you should be talking about, certainly not Facebook or Twitter or any of that other wonderful stuff. Consider retaining your own attorney if a group is involved. Even if the group has an attorney, get your own. Never change your record after learning about a lawsuit. That would be incriminating to you. Be careful when giving depositions. And in your course, I have put a YouTube that is Deposition 101. Have any of you ever given a deposition? No?
I've given one when I worked for disability insurance. I've given a couple.
And how did that go?
I didn't care for it. It always feels as if they're not looking for the truthful answer. They're just looking for trying to phrase questions to get you to say what they want to benefit their case. The company was being sued for disability insurance, and I had reviewed medical records. So it was I just didn't feel like they were looking for the truth of what I saw in the record. Just wanted me to say things a certain way for their client's sake.
Well, yeah, giving a deposition can be a little bit of a nervous event, but they give really good suggestions about that on that YouTube. So if you get a chance, that would be great to look at. And think carefully before agreeing to settle. I think they talk about one doctor in one of the videos I was looking at that settled the case outside of court, but then they felt like that they hadn't been vindicated. You know, they hadn't been proven to be innocent. They had just settled it without right or wrong or innocence or guiltiness. And they didn't really want to do that ever again. Good communication means better outcomes and higher patient satisfaction. And satisfied patients generally do not sue. So, that's frequently asked questions about malpractice. Do I need it if my employer covers me under their insurance policy? That would be a yes. Am I more likely to be sued if I have malpractice insurance? Well, if you tell people, make an announcement that you have malpractice insurance, then that is a possibility. Should I get claims made or occurrence insurance? What do you think?
occurrence made. Occurrence insurance.
Right. Uh-huh. It covers any incidents that occurred while the MP was insured. Under claims made, an MP is covered only when the insurance policy is active, no matter when the incident occurred. Even if an MP stops practicing, they must keep paying a claims-made insurance policy to receive coverage for incidents that happened in the past. Extend claims policy to a tail policy. Which company's policy is the best? Get one that's in the United States. They've been in business for more than 10 years, and they have stable financial ratings. So you do need to kind of shop around and make sure that you get one that meets those criteria, but always a current. Because after you quit practicing, you're still going to be liable. And if you're a pediatric nurse like I was, for 21 years, you're going to be liable. So I have to stop and think, who was the last little kid and when did I treat them? And I probably will not live long enough for them to reach 21 and sue me. That's the good news. The bad news is there's still some along the way that could. Risk management. Nurse practitioners are at risk for clinical mishap and business mishap. Clinical mishap broadcast by patients can end in business losses. So if you do something wrong in your clinic that you're owning, it can influence the bottom line, of course, in your business. All MPs face certain risks associated with practice. Making a clinical error, being sued for malpractice when there was no clinical error, public perception that MP is a poor quality provider, exceeding legal scope of practice, breaching patient confidentiality, failing to inform patients fully about treatment and to get informed consent to treat, poor quality ratings, disciplinary actions, being accused of Medicare fraud. For most of that Medicare fraud is for upcoding a patient visit. Business failure is a result of undercoding. You undercode, you don't get enough money, then you don't stay in your office because you can't support yourself. And being accused of prescribing or dispensing controlled drugs inappropriately. So those are all things that could affect your business and your practice. So the risk of making a clinical error. Being sued often sours the nurse practitioner toward the profession and is a devastating experience for them. So we talked a little bit about what is malpractice. It was actually, there has to be a relationship, a duty of care. That care has to be below standard. There has to be a link between what you failed to do and what happened to the patient to cause harm, and then the patient has to have actual injury. So, professional relationship, what is that? Over the phone, like at a party, supervising another's treatment, providing sample medication. Oh, here, take this. I didn't use all of it for my doctor. By giving advice or opinions to family or friends. And nobody is going to be your friend if they get hurt. Just remember that. Most friendships go out the window when there's serious harm done. When is a person a patient? If you call in a prescription for someone who's not your normal patient, then guess what? That person is your patient. But you can politely refuse to give advice other than, she should call the person's pediatrician or require that the sick person come into the office and go through the usual patient evaluation. The MP would be liable if the mother makes an erroneous diagnosis, the mother does not know the organism is resistant to the antibiotic used in the past, or there is some other problem that would have been diagnosed after careful history and physical exam. So you don't know that patient, you haven't laid eyes on that patient, it's very difficult for you to make a really standard of care opinion about what's wrong with them and what they need. A standard of care, again, it's the ordinary care or diligence that would be given by a practitioner in the same geographic area and the same general type of practice in similar cases. So they look at all that. You're compared to other people. So how do you keep up with the standard of care? Well, those are listed, many of the ways that we all do keep up. And in the state of Tennessee, you're required to keep up with your continuing education. So that's not an option. You're actually required to do that. Diffusing the risk of being sued and labeled poorly. Keep the patient satisfied and appeal mostly to the dissatisfied patient. A lot of patients are dissatisfied. Many will not tell you. Beware of the one that does. Avoid lawsuits by reducing the length of time for appointments, like long waits in the office, impersonal treatment, constant busy signals when they're trying to call you. So if you have an office yourself, it's your office, be aware that the front office can actually put you at risk of being sued if they're ugly. 90% of patients who are dissatisfied don't complain. Pay attention to those that do. Shore up your reputation by following up, being attentive, on time, keeping promises, looking professional in appearance, language, or intellect, being reliable, or making decisions based on evidence-based practice. It's really important that you do that. So how can you cause
I have a
problems?
question.
Uh-huh.
The previous slide,
Uh-huh.
it says 90% of those who are dissatisfied don't sue.
They
Pay
don't
attention to
complain.
those who do. Is
They
that
don't.
not the reverse?
No.
90% of those who are satisfied don't complain. Pay attention to
Uh-huh.
those who
Do.
are not
What
satisfied.
that's saying is it doesn't have necessarily to do with lawsuits, exactly that little part. 90% of people that are not happy about how their visit went or the care that you gave will not tell you. What they will do is they will go somewhere else. What this slide says is if they tell you they're dissatisfied, then try to remedy it. I can give you a good example of when I worked at the clinic. They brought back this elderly woman and her friend, and she had trouble with her foot. And actually, she had broken her foot, as evidenced by some x-rays she had had somewhere else. She was coming to our clinic to get her foot cast, put in a cast. Well, we don't do that, and we didn't have any available x-ray to confirm that she had broken her foot. So I told her, I'm sorry that you came back here, but I really cannot help you. We do not do casting here, and our x-ray person is not available. They're not in the building at this time. So you will have to go over to the hospital, okay? So she went out to the front, and I kind of followed along with her, and I told the front office, do not charge this woman. I didn't do anything for her. But the office manager said, yes, we're going to charge her $25 because she went back there and you saw her. The woman looked at me and said, I'm going to report you, me, to the State Board of Nursing because you did nothing for me. And I said, hold on just a minute. I went back to the office. I wrote the woman a $25 check. I said, give me that paper that you just got through filling out to report me. You deserve your refund back. I will give it to you. Just give me the paper. So she handed me the paper in exchange for the check. I knew she was trouble. She was going to make trouble, not just for me, but for the clinic as well, and go out and tell 9 other people how awful we were that we didn't look after the patients, even though I very calmly explained to her that was something we didn't do there. So you need to pay it, not necessarily you need to, grab your checkbook and write the $25 check, but I didn't want to get into trouble for something that I didn't do wrong. So I did, that's probably one of the few times I've ever done anything like that. But you do have to pay attention because those are the very people that are going to cause you trouble. They're going to sue you. There are people that are litigious, I think that's the name. Did that help answer your question?
Yes.
Okay. So how do you breach confidentiality? Well, you can talk about patients when other people can hear. You can send their medical information somewhere without their consent. You can leave telephone messages on their answering machine, which is always dangerous, I think. You can discuss the patient condition with family members who the patient may not have given you permission to do. You can get rid of unshredded duplicate records for other people to find. Give the patient's name to a vendor so they can call them up or make a visit to them. And for curiosity, look at somebody's records to see what were they actually in here for. Leave your laptop, if you have that information on it, in a subway train or restaurant, and then fax patient data to the wrong number by mistake, which is always, you have to be really careful when you're doing that you don't get it to the wrong place. Informed consent, they have a right to refuse or to consent. You have a need to give them enough information that they can decide if it's going to be a risk or a benefit, in which way that's greatest. They must be competent to consent. They can't be drunk. The informed consent arose out of a societal need to discourage people from touching of us. That's how come we had informed consent to begin with. If you did touch somebody, then the informed consent would be under the law of battery. But it's evolved to the act of self-determination instead. So if you didn't give them enough information, it's called negligence. If you don't give the informed consent, it's called battery. Either way, the patient can sue. It must, in all likelihood, be an invasive procedure, but cases have been poised against oxygen therapy for neonates, radiation therapy, genetic counseling, gastroscopy. So there are other things that can cause you to be sued. Your responsibility is to communicate the information to the patient when the exigencies of reasonable care call for it. Alert the patient to symptoms of bodily abnormality. Inform the patient when the ailment does not respond to what you're trying to do for them. Instruct the patient about any limitations to be observed for their own welfare. Inform the patient of the need for or desirability of any alternative treatments that might have better benefit. Advise the patient of risk to their well-being that the contemplated therapy may involve. And then there was the citation of Canterbury and Spence, which involves all of these things that we have been talking about. Covering the risk of battery charges. So you can prevent that by giving them information, risks, benefits, alternatives, and get a written consent. Find out what the state law requires about informed consent for different things that you might do to them. Give the patient information on the risks, benefits, and alternatives to any treatment, including prescription medication, and ask for their agreement to the treatment. There should be a partner in their treatment. Document the information about the risk, benefits, and alternatives to the treatment has been given to the patient, and the patient agrees to the treatment. So before they leave your office, they should agree to do whatever it is that you had intended to do with them. In an emergency, it's a special case, or incompetency. So if they've been unconscious, developmentally disabled, judged insane, cannot read, write, or hear, under the influence of sedative drugs or alcohol, then they're incompetent to give consent. And there was just a case not too long ago, where was it, in Utah, where the nurse refused to get the blood from the patient who was out of it, and the police arrested her. You remember that? That just happened not too long ago. And NP should avoid treating such patients unless a parent or a guardian is available to give consent. And minor children can never consent to treatment. They assent to research, but they cannot consent to treatment. Parental consent is always necessary. So risk of negligent non-disclosure. When you know the risk but you don't tell them, and then they're harmed from that risk. So then you have a causation. Consent is applicable when the treatment is proposed. Non-disclosure is applicable when an omission of information leads to an injury. So you always want to tell them the truth so that you're not going to be held liable for not telling them. So where do quality ratings come from? They come from HEDIS, which is your health plan employer data and information set. If you have your own business, then they will come and gather information from you, and then you'll be judged on your quality of care. And then Medicare also collects information if you are using, Medicare in your practice. The risk of disciplinary action: a board of nursing can revoke, suspend an NP's license based on gross negligence, and certainly malpractice, impairment, fraud, or criminal activity. So you can lose everything that you've worked for. And how does, question? How does this go? Well, you get a letter saying that you're going to be investigated. And then you meet with an investigator, and they're in the data gathering mode. So they will try to gather the information about the event from all the sources, and you can recommend sources of people that would know something on your behalf. The investigator will recommend that the investigation be dropped, or will recommend a hearing. An administrative hearing resembling a trial will be held, and the nurse practitioner should take her attorney or his with them. May give the nurse the option of a pre-hearing settlement conference. A hearing officer will then make a recommendation to the board. The board will decide to drop the matter or discipline the nurse. Discipline could mean probation, suspension, or revocation of license. And sometimes, after passage of the time, the nurse whose license is revoked may reapply for licensure. Scary, huh? Risk of Medicare fraud. Whatever you bill should match the level of care. So upcoding is what usually gets people in trouble. So the CPT codes usually tell you how much you have to acquire history-wise, a physical exam, how much you have to do, or how complex the medical decision making is, and that's what you base your coding on. So coding can get you in trouble. And then the book goes a little bit in about rules in starting a business, that you need to decide who the boss is and who's going to make the decision. get you some bylaws that are spelled out with regard to the chain of command. So drawing up an administrative chart should be one of the first tasks in the planning process. So when you make your business plan, if you go by this, one of the first things you want to do is do the hierarchical chart on who reports to who and who has the power to make the decisions with things like money. Because most of the businesses that fail, the partners split because they haven't agreed on the front end who's on first base. So dealing with high-risk patients, who are the ones most likely to sue you? The multi-system failures, probably you need to refer them. The intellectual disabled, the polypharmacy patients, the non-compliant patients, the ones with positive review of systems. They have so many things wrong with them. The substance abuse patients, and the ones that talk about all the lawsuits they had and did before they ever came into your practice. So all of these patients should be red flags to you and pay particular care with dealing with them and documenting with regard to them, because these are the patients that will more than likely sue somebody sometime. So you have a risk of being accused of prescribing and dispensing controlled drugs inappropriately. So you don't individualize the treatment. You don't tell why you're giving it. You don't follow the standards in pain management that your agency has put in place, hopefully. You don't exhaust other methods other than drugs to relieve pain. You don't use evidence-based treatment. You fail to develop a treatment plan that matches the assessment, and then you don't monitor for aberrant and or drug-seeking behavior. I can give you an example. I was taking care of a little boy that had been brought down, well, he wasn't little, he was an adolescent, had been brought down from the north by his grandmother to spend time with his mother, who, by the way, had a history of amphetamine abuse. He was diagnosed with ADHD. So she came and said that he needed his Ritalin. So I tested him for Ritalin, amphetamine. He didn't have any in his system. He had marijuana in his system. I never treated them again. I called her up and told her I wasn't going to treat them unless she would, let me test her. And she refused, and so they went somewhere else. To lower the risk of prosecution, never prescribe. It gives you those 3 drugs together. Perform a documented evaluation that gives the reason why you're giving a drug. Check the prescription drug database before you give it. Contract with the patient, how they're going to take it, how long they're going to take it. And every 6 months, order urine screens, because they may not be taking the drug. And evaluate the progress and see if they're making progress. If they're not, discontinue it. And then you can check the state's prescription drug monitoring program before dispensing an opioid. And one of your best people to help you with all this is the pharmacy. Electronic medical records do help. You know, a lot of errors were due to illegible writing, handwriting, but now we don't have that problem. But there's so many templates and built-in safety mechanisms with electronic medical records and clinical support that it's really a big help. But the records sometimes look like they belong, all of them, to the same patient, and you can click the wrong thing or not put it in the right template or even pull up the wrong patient with medical records. So they're not without amount of error. Okay.
The clinic that I'm at right now actually still uses paper charting.
Uh-huh.
Which is the first experience for me.
You never used paper charting before?
I've
See,
never
up until, I always used paper charting, so when I went to so many different electronic medical records, it was like, oh my gosh, how do I individualize this? They all read like they're widgets. You know, they all look the same if you just click and don't do text. And if you do text, they may not print out or even, be accessible. So I struggle with electronic records a little bit.
It's more like I seem like I can't find the patient folder with all their stuff in it because it's just scattered everywhere. Like they have patient documents just piled high in their office. It's crazy.
It's like peeling an onion, is it not? You have to peel to get to what
It's
you
like
need.
3 folders for certain kids, and you're like, how many times have they been here? This is crazy. Yeah.
I know it. And when you change over to another EHR, you may lose all of that information that you had in the original one. It may become inaccessible. And to me, that's a big problem. I know when we went from paper charts to electronic medical records, we were supposed to have somebody scan all that in. That really never happened. It was a monumental task. And so any history that the patient had, the best thing would have been if it would have been summarized and scanned into the chart by somebody, that they just go through that knew what they were doing. Just summarize it and then scan it in. You cannot scan in the whole chart. It's just, with hundreds of patients, it's too much. But somebody somewhere needs to summarize it so you have some hope of getting a good starting place with your patient, for sure.
Yeah.
It's not without its problems. Any other comments or questions?